Daughter called me at 11:43 on a Tuesday night in January, and the first thing she said was not hello. She said, "Mom, he's gone. He took Lily and he's gone, and I don't know where they are." I was in my kitchen in Oakville. I had been reading. I set the book down, face first on the table, and I did not move for a moment. Just listen to her breathing on the other end of the line. That particular kind of breathing that tells you someone is trying very hard not to come apart in front of you. "When did he leave?" I said. "This afternoon." I came home from work and the house was empty. Not just him. Lily's room, her clothes, her backpack, the stuffed rabbit she sleeps with. Everything. I looked at the clock on the microwave. It was almost midnight. "Are you at the house now?" "Yes." "I'm coming," I said. She started to say I didn't have to, that it was late, that she was fine. I had raised her so I knew what fine sounded like, and this was not it. "Lock the door," I said. "I'll be 40 minutes. My name is Winifred Alcott. I am 64 years old. For 30 years, I worked as a senior forensic accountant with a firm in Toronto. The kind of work that most people find very dull until it is suddenly the most important thing in their lives. I retired 2 years ago, and I moved to a smaller house in Oakville, and I planted a garden, and I started learning Italian, and I genuinely believed that the part of my life that required me to sit in airless rooms and trace money through shell companies and holding accounts was finished. I was wrong about that. My daughter's 31. She is the kind of person who notices when the person next to her on the bus looks sad and does something about it. She became a physiotherapist because she wanted, and I am quoting her directly here, to help people feel better in their actual bodies. She married my son-in-law 4 years ago in a small ceremony at a vineyard in Niagara-on-the-Lake, and I stood in the back row and cried in the way that mothers cry at weddings. Which is not entirely from happiness, but from a complicated mixture of things you cannot name while they are happening to you. My son-in-law's name is not something I am going to use here. I will call him what I now understand him to be, which is a man who spent 4 years building a life on top of a trapdoor he had installed himself. His family had money. Not the quiet kind of money that sits still, the kind that moves around and talks about itself. His father ran a property development company in Mississauga, and my son-in-law had been brought into it when he was in his late 20s, given a title and an office, and the strong impression that one day it would all be his. What nobody told my daughter, what she had no reason to think to ask, was that his relationship with his father was not what it appeared to be. What it appeared to be was close. What it actually was, I came to understand, was contingent. They bought a house in Burlington 3 years ago. It was a good street, the kind where people have window boxes and wave at each other. My daughter had saved carefully. She had been putting money away since she was 23, small amounts at first and then larger ones. Because she had grown up watching me and she understood that financial independence was not a luxury, but a form of self-respect. She had $58,000 saved. That money went into the purchase. My son-in-law's father contributed $90,000 and his name went on title alongside my son-in-law's. My daughter's name did not. She told me this at the time and I asked her about it, and she said her husband had explained it was a tax arrangement, that his father's accountant had structured it that way, that it was temporary and would be sorted out once the mortgage was refinalized. I am a forensic accountant. I understood exactly what a title arrangement like that meant. But my daughter was happy and I had watched her be cautious and careful for years, and she wanted very much to believe she had landed somewhere solid. I said, "Be careful." I said, "Get it in writing." She said, "Mom, it's family." I know. I had thought about that conversation many times in the 18 months since. I drove to Burlington on empty roads. It was January, and the 403 had that particular quality it gets in deep winter. Black ice hiding under a surface that looks merely wet. I drove carefully. I had time to think. By the time I pulled into her driveway, it was nearly 1 in the morning. She opened the door before I knocked. She was still in her work clothes. She had been crying, but she was not crying now. She was past crying and into something quieter and more frightening. The kind of stillness that sets in when a person has moved through shock into something that doesn't have a good word for it. I came inside. I did not say anything that was not useful. I put the kettle on and I sat down across from her at the kitchen table, the one she had picked out herself from a shop on Lakeshore, and I asked her to tell me everything from the beginning. It took 2 hours. What had happened, as best she could piece it together, was this. 3 weeks earlier, her husband had told her he wanted to separate. He had been distant for months, she said, and she had thought it was work stress because his father's company had been having difficulties. She had tried. She had suggested they see someone together. He had agreed, and then there was always a reason it didn't happen. When he told her he wanted out, he told her in the kitchen on a Sunday morning. And the thing she remembered most clearly was that he didn't look sad. He looked like a man who had already finished grieving something and moved on while she wasn't watching. She had thought they were going to have a hard conversation about how to separate with some measure of decency. Instead, 3 weeks later, on a Tuesday afternoon in January, she came home from work to an empty house. Her daughter's room cleared out. A note on the counter. The note said Lily was with him at his parents' house in Mississauga and that his lawyer would be in touch. He had taken their daughter across the GTHEA without telling her where he was going and left a note on a counter. I read the note. Then I folded it very carefully and I put it in my bag. "Do you have his lawyer's name?" I said. He didn't say. "Does Lily have her medications with her?" Lily is 4 years old. She has a mild allergy, nothing dangerous if managed, but it requires a specific antihistamine that they keep in a kitchen cupboard. I don't know. I looked at my daughter across the table and I made a decision that I have never regretted. "You are going to call the police non-emergency line right now," I said. "You are going to report that your daughter has been removed from the family home without your consent and you do not have a confirmed address for her. You are going to be calm and clear when you say this. Can you do that?" She looked at me. Is that what I should do?" "Yes," I said. "Right now, tonight. And then I am going to make some calls in the morning." She called. I sat beside her and listened. The officer she spoke to explained that because the parents were still legally married and there was no custody order in place, what had happened was not technically abduction under the criminal code. He said that, and I want to be precise here because I know this is something people listening may not understand, in Canada, without a court order specifying custody, both parents technically have equal right to be with the child. He said she should contact a family lawyer immediately. I already knew this. But I also knew something else that the officer on the phone did not mention, which is that removing a child from their habitual home without notifying the other parent and failing to provide an address is exactly the kind of conduct that family court judges in Ontario take very seriously when determining parenting arrangements. My daughter slept in her bed that night, and I slept in Lily's room, on the floor on a yoga mat, because I did not want her to be alone in the house. And I am 64 years old, and I have slept on worse. In the morning, I made oatmeal, and I called my former colleague, Hugh Baxter. Hugh and I worked together for 11 years. He left forensic accounting in his early 50s to become a family law litigator, which surprised everyone who knew him because he's a deeply patient man, and family law is not a field that rewards patience. But he is also very precise and very quiet, and there is a particular kind of client who needs someone like that across the table from them. Someone who does not perform and does not alarm, but who simply knows more than the other side expected. I laid out the situation. He was quiet for a moment in the way he always is when he is organizing information. "The child is in Mississauga," he said, "with his parents. We have an address from a Christmas card from 2 years ago. And there's no parenting order. Nothing. The $58,000, he said. How was it transferred? Her account to the purchase account. I have the bank records." He was quiet again. "She's not on title." "No. Eleanor," he said, and then stopped. "Sorry. Winifred." Do you still have access to your databases? I told him I did not, that I had retired, that I no longer had institutional access to the financial tracing tools I had used professionally. He made a sound that I recognized. It was the sound of a man mentally adjusting his timeline. Give me everything she has, he said. I'll file for an emergency parenting order today. I need you to go through whatever records she can access and tell me what you see. My daughter had access to their joint account. She had access to joint credit cards. She had saved, and this is not something I taught her directly, but I am glad she absorbed it somehow. She had saved screenshots of financial statements over the years, not obsessively, just periodically, the way some people take photos of parking spots to remember where they left the car. She had not known why she was doing it. She had just had a feeling. I sat at her kitchen table for 3 days with her laptop and the yellow legal pad. On the second evening, I found something. Starting about 14 months earlier, there had been a series of transfers out of the joint account. They were not large individually, $200 here, $350 there, sometimes $400. They went to an account listed in the records only as a reference number. If you were looking at a monthly statement and not looking carefully, they read like utility payments or subscription services. Over 14 months, they added up to just over $22,000. I wrote down the reference number and I sat back and I thought about it. I am not a private investigator. I no longer had professional tools, but I am a person who spent 30 years understanding how money moves when people do not want it to be seen, and there is a grammar to it, a recognizable structure. Small amounts, irregular intervals, reference numbers instead of payee names. This had the grammar of concealment. I called Hugh the next morning. I need you to run a production order on an account, I said, and I gave him the reference number. He was quiet. You found something? I think so. Yes. It took 10 days. In that time, Hugh filed the emergency parenting order and a judge granted interim access, meaning my son-in-law was required to bring Lily to a specified location 3 times a week so my daughter could see her. The first time happened in a Tim Hortons parking lot in Oakville because it was halfway and it was neutral ground and my daughter sat in her car for 20 minutes afterward and did not drive. I sat with her. We watched a man in a Canada Post uniform load packages into his truck. A woman walked past with a dog wearing a jacket that matched her own jacket. We sat in the cold car and we didn't talk for a while and then she said, "She looked okay. She looked okay, right?" And I said yes. Because Lily had looked fine, she had run to her mother and grabbed her around the knees the way 4-year-olds do, and for the 20 minutes they had together, she had been completely herself. She had looked fine. I was not going to say that and have my daughter not believe me. So I said it twice. She looked okay. Yes. The production order came back. The account belonged to a numbered company registered in Ontario. I polled the corporate registry, which is public, and the sole director of the numbered company was my son-in-law's father. I sat with that for a long time. Then I called Hugh. "His father," Hugh said. "Yes." There was a pause. He was setting up a parallel asset before the separation. That's what it looks like. If he knew the marriage was ending and he began transferring marital funds 14 months ago, he did know, I said. He told her he wanted to separate 3 weeks ago. He had been distant for months before that. If these transfers started 14 months ago and he was already disengaged from the marriage, then the transfers predate the separation conversation by nearly a year. Yes. You made the sound again. The timeline adjustment sound. I want to say something about what I felt during those 10 days and in the days after because I think it matters. And I think it is often left out of these kinds of stories. I was not angry. I want to be precise about that. I have been angry in my life, and I know what it feels like. What I felt was something closer to a very cold, very focused clarity. A woman had spent 4 years in a marriage where the floor had been built with a mechanism to drop her through it. She had put $58,000 into a home she was not named on. She had built a life in good faith, and the people on the other side of that faith had been making arrangements. That kind of thing does not make me angry. It makes me very, very careful. We filed 3 things. First, an unjust enrichment claim for the $58,000 my daughter had contributed to the purchase of a property from which she had been entirely excluded without compensation, representation, or agreement. Second, a claim for recovery of the $22,000 transferred to my son-in-law's father's numbered company from the joint account during the marriage, on the basis that these were marital assets diverted without consent. Third, and this one was Hugh's idea and I think it was the right call, we filed a motion for full financial disclosure in the parenting proceeding, because the way assets had been structured and moved suggested a pattern of financial concealment that the court needed to understand in the context of credibility. My son-in-law retained a family law firm in Mississauga. There were 4 months of negotiation. I am not going to pretend they were easy. There were weeks when my daughter woke up at 3 in the morning and sat at her kitchen table until it was light, and I know this because she called me and I stayed on the phone. There were weeks when she questioned whether fighting made her the person she wanted to be, whether she should just accept less and be done with it, whether Lily was being affected in ways that wouldn't show up until later. I did not tell her what to feel. I told her what I knew, which was that the people who had done this were counting on exactly those feelings to do the rest of their work for them. She kept going. The unjust enrichment claim was settled out of court. My daughter received $51,000, not the full $58,000 but close, and achieved without trial, without a judge, without putting either of them through that particular machinery. The claim regarding the transferred funds was more complicated. My son-in-law's father retained his own counsel separately. The eventual negotiated resolution required the numbered company to return $17,000 to the joint pool to be divided as part of the separation agreement, not the full $22,000. In these matters, you rarely get the full amount. But $17,000 is not nothing. It is a number that says, we found it, and we made you give it back, and you will not forget that we found it. The parenting arrangement took longest. There were 3 appearances before a judge, 2 mediations, and 1 session with a parenting coordinator. What emerged was a shared parenting plan, 1 week on and 1 week off, with decision-making shared on major issues and a communication protocol in place because it had become apparent to everyone involved, including ultimately the lawyers on the other side, that direct communication between the parents was not yet productive. Lily is now doing 1 week with her mother and 1 week with her father. On the weeks she is with my daughter, she sleeps in her own room, which my daughter repainted over a weekend in March, the 2 of them together. Lily, in a tiny paint-spattered apron that used to be mine, choosing the color herself. A yellow called buttercream that looks different at different times of day. On Sunday mornings, Lily and my daughter come to my house in Oakville, and we make pancakes, and Lily stands on her step stool at my counter and pours in the blueberries at the exact right moment, very seriously, because she has decided this is her job and she is not wrong. She told me once that my kitchen smells like syrup and the color blue. I told her I was not sure what the color blue smelled like. She said it smelled like my kitchen. I decided she was right. There is something I want to say about the financial part of this, because I know it is what some people will focus on, and I think it deserves honesty. My daughter got back a significant portion of what had been taken or excluded. She did not get all of it. The legal costs were real. The time was real. The sleepless nights were real. Anyone who tells you that pursuing this kind of thing is straightforward is either lying to you or has never done it. But here is what is also true. My son-in-law's father had structured a situation in which my daughter would walk away from 4 years of her life, including $58,000 of her savings, with nothing but a parenting arrangement that had not yet been established and a note on a kitchen counter. That was the plan. She was supposed to be too exhausted, too heartbroken, too uncertain about the law, too worried about her daughter to look closely at any of the financial arrangements. The complexity was the point. The confusion was load-bearing. What he did not plan for was me. I want to be clear that I am not saying this to make myself sound important. I am 64 years old and I live alone in Oakville and I grow tomatoes in the summer and I am learning, slowly, to conjugate Italian verbs in the subjunctive. I am not important. What I am is 30 years of knowing how money moves when it does not want to be seen. My daughter has a house she is buying now in Hamilton. A semi-detached on a street with mature maples that go extraordinary colors in October. Her name is on the title. Just hers. She called me the evening she got the keys and I drove over and she met me at the door and she did not say anything for a moment. She just stood there in the doorway of this house that was hers, all hers, nothing conditional, nothing arranged against her. And I looked at my daughter and I thought about everything she had put into the 4 years before this one, and about Lily in a yellow apron pouring blueberries with great seriousness, and I thought, okay, I am telling this story because I know there are people who have been handed a note on a counter, who came home to an empty house, who were told by someone who had taken things from them that the taking was legal, that the arrangements were airtight, that they had no standing. I am not a lawyer. I cannot tell you what your specific situation looks like or what you should do. What I can tell you is that in my experience, which is long, the people who structure these things almost always assume that the person on the receiving end will not know what they do not know. They count on the paperwork being impenetrable. They count on the grief being heavy enough to do most of the work. They count on you not having someone who will sit at your kitchen table at midnight and go through 4 years of bank statements with a legal pad and a cup of tea that went cold 2 hours ago. You cannot always find that person. I know that. I know that I was lucky to be the person my daughter could call. But I want you to know that person exists somewhere. That if you look, if you ask, if you tell someone what happened to you instead of carrying it quietly because you are afraid it sounds too complicated or too small or too much, there is almost always someone who has seen this before, who is not afraid of the paperwork, who knows the grammar of concealment. You do not have to understand all of it yourself. You just have to make the call.